seminal case. I had to look this up, but it was here in San Diego in the past. Um, our listener was curious in the Leader versus Cords case. Was Terry Cords found to have acted in bad faith?
So I don't know the answer to that question, and maybe Keith does. But first of all, leader versus courts, what the case stands for is that a trustee doesn't only have the duty to account to the trust beneficiaries for what's in the trust and how much, what are the assets, what are the liabilities, how much money that the various beneficiaries should receive. It's so funny. When we have a conversation like this, you're like piercing your eyes through me, which you normally
Oh,
don't.
sorry.
You normally don't do during a
I'm
normal
really paying
conversation.
attention.
You're just like,
Really,
what's he going to say next?
yeah.
So I'm like, am I saying this wrong?
No, it's
Okay.
over.
So the beneficiaries are entitled to an accounting, and so. But what Leader versus Courts really does is it stands for, you can look at me, Keith.
Okay.
What Leader versus Courts really says
I'll
is,
try not to make it look like I want to kill you.
Yeah, you look like an interrogator. You would do well in the KGB.
Yeah,
You just walk into the room and start staring at people. They're just like,
Yes.
So what Leader versus Courts really did was it said that the trustee has a duty to deliver the assets to the trust beneficiaries. So how does this come up? A very controlling trustee takes over, doesn't like their brothers and sisters, and wants to be difficult to deal with, and says, "Oh, I've got the money. I'm just not going to make any distributions right now." And that's not the trustee's job. The trustee's job is to account for the assets, pay off all the creditors, and make distributions in most plain vanilla trusts. Some trusts, they have discretion, but the mandatory blow-through trusts where you got to make a distribution, they've got to make these distributions, and they don't. And so Leader versus Court says, no, you can't do that. You can't just hang on to all these assets. You have a duty to account. That's wonderful. That's good. But you also have a duty to distribute assets to the beneficiaries. And that could be a preliminary distribution. It could be a final distribution. You just can't hang on to millions and millions of dollars and not make a distribution. You can hold a reasonable reserve. And I don't know if Leader versus Court goes into that, but you can hold a reasonable reserve as a trustee to pay for outstanding, tax liabilities or your attorney's fees or whatever the case may be. But you can't just simply hang on to the assets. The question about bad faith really goes to a provision in the probate code that says if a beneficiary or a trustee, either one, does something with an accounting in bad faith, the judge has a right to shift the bad acting or the rightful party's attorney's fees to the bad acting party. And that could be either or. So if you're a beneficiary, why don't you walk us through this, Keith? If you're a beneficiary, how do you act in bad faith? And if you're a trustee, how do you act in bad faith?
It's a very difficult question to answer just because bad faith is a little bit of a nebulous concept. What exactly does that mean? And it's completely at the discretion of the trial judge. And so the judge gets to decide if it was bad faith or not. But typically bad faith means that you've done something above and beyond just objecting to an accounting. So whether you're a beneficiary or trustee, if you object to that accounting in bad faith, meaning you're doing it for reasons that aren't legitimate to the accounting, you're doing it to try and cause people, problems, or, a trustee is just trying to abuse their position. So a lot of times, judges will point to the actions that the trustee takes during the litigation. If they just, they go too far in terms of what they're doing, or, they take, 50 depositions and it's a case where they're litigating over $10,000 or something along those lines, where it just seems very excessive. But it's hard to answer the question of what is bad faith, because it's kind of like, I forget which Supreme Court justice it was when they were trying to decide on pornography. And the justice says, well, I can't describe it, but I know it when I see it. I know the difference between art and pornography when I see it. Mm-hmm. And bad faith is kind of the same way, as the judge knows it when he or she sees it. Mm-hmm. But if you come to me as a client, or the client goes to you and says, okay, here's what's going on. Is that bad faith? It could be, or it could not be. I don't know. But it doesn't matter. You have to argue bad faith. If you want to try and get attorney's fees, you have to argue that the other person acted in bad faith. And that leads us to a broader discussion of, why a lot of times people come in and they think, well, I should be paid my attorney's fees. I wouldn't have had to do this if this trustee wasn't bad and doing the things that the trustee shouldn't be doing. And I think people are really shocked at how rarely courts will award attorney's fees. And that's kind of a more broad discussion of why is that? Why is it that judges are reluctant to shift attorney's fees? In the American system, everybody pays for their own attorney's fees, whether you win, lose, or draw. which apparently is very different from like the United Kingdom, where the winner by law gets their attorney's fees. So our system is based on this idea that everybody has to pay their own, except for limited exceptions. And I think a lot of judges, at least in my opinion, they see the shifting of attorney's fees as being punitive. And so they'll do it, but only in situations where they feel like it's the right solution to the problem, not because you had to come in and do something because this trustee is being difficult, but because there was something more than that. I think the judges want to see something more than that in order to shift attorney's fees. But what are your views on that?
Well, so the general rule is you're going to have to pay your own attorney's fees. So
Right.
people should just assume that's going to happen like 90% of the time. There are two exceptions. One is statutory in nature and the other is contractual in nature. So if there's a contract that you sign with another party that says if you're the prevailing party in a litigation in the future, because you don't know if you're going into litigation or not when you're signing the contract, that the prevailing party gets their attorney's fees. So the court has authority at that point to follow the terms of the contract that you entered into with another person. And if you're the loser in that case, you're likely going to have to pay the attorney's fees of the prevailing party. And there's a prevailing party. I mean, just for definitions here, it's the person who wins, but there's an analysis that takes place there of who's a prevailing party. Because sometimes you win part of the case, but not the other. Are you the prevailing party? So you look at some rules there. But ultimately, just keep in mind that if you win the case and it's under contract, the other thing is there's some statutes out there that allow for the attorney's fees to the winning party. If they win and are successful, they get their attorney's fees paid. So those are out there. Financial elder abuse is a good example. The financial elder abuse statute, which is put in place to protect elders over 65, where there's an exercise of undue influence over that elder to take their assets away somehow, some way, whether it's through an estate plan or a will or a trust or whatever. If you take an elder's assets, anyone that's over 65, and somebody sues you for that and you lose that case, you're not only going to have to return those assets, but you're going to get hit with their attorney's fees. And so that's how that generally works.
That probably happens more when the elder is still alive. But when we bring financial elder abuse once the elder is deceased, I think it becomes much more difficult to get your attorney's fees once the elder's passed. Because again, I think the judge is looking at this saying, well, these are two parties, they're fighting over assets. You know, yeah, you had to incur attorney's fees, but so did the other side. You know, you all have been kind of equally damaged in that regard. We just don't see courts shifting attorney's fees with the exception of contractual obligations. That's different. But we don't see it happening that often. And the problem is, I think most people think it should happen and it doesn't. And unfortunately, I think there's attorneys out there who will tell people, yeah, I'll get your attorney's fees for you. They won't. 9 times out of 10, they won't. And so I think it's at least good to be honest about it up front, is that, yes, you can ask for it. And yes, we can argue for it, but you should assume you won't get it. And that way you won't be disappointed.
Well, and I mean, really what it comes down to is you don't do very well at your arguing for attorney's fees. I've listened to you ask for them and you do terribly. So that's probably,
is that the problem?
That's probably the reason why you're not, you know, so that's, no, I say that tongue in cheek because that's probably how clients feel, because they say, well, the statute says I get my attorney's fees. How come I didn't get them? And as you pointed out, and rightfully pointed out, judges just are reluctant, at least in the financial elder abuse arena. And it's strange to me that they are.
Or even bad faith.
Even bad faith. They just don't seem to do it as often. Now, I am seeing more and more judges doing it. I'm also seeing more and more awarding attorney's fees. I'm also seeing more and more judges issuing sanctions against bad acting attorneys who refuse to answer discovery. Discovery is, you know, it's, you might as well take 2 pencils and stab them in your eyes, and that's better than going through a discovery fight. Many times you get such sloppy answers, you just got to set up depositions and take depositions to figure out what's going on. But the written discovery is really nasty, but we're seeing more and more judges issuing sanctions, and they're not huge sanctions, but even a $500 or $1,000 sanction, it gets the attention of the bad acting attorney.
Yeah. And I mean, I think the more the courts do that, the better. But yeah, it just be aware that it's not such a sure thing like people think it is. We love Leaders v. Cords. We've used that case tons of times in order to force distributions, because you have these trustees who simply don't want to make distributions. And Leader versus Cords is a great case in that regard.
Yeah, there's actually a sentence in Leaders versus Cord that we use in our motions. It's in there. You'll find it. And it says it's not just the duty, something to the effect of, it's not just the duty to account, it's the duty to deliver. And it's such a powerful sentence.
Yeah, it really is. And I don't know specifically if they found bad faith in Leader v. Cords, but I do know that the court awarded attorney's fees. And there's a concept under appellate law that if the court awards a certain result, then there's an assumption that they found all the elements that they needed to find in order to get to that award. So if they awarded attorney's fees, there's an assumption that the court did find bad faith.